Yeah, good afternoon, everyone. I've got 2 minutes after the hour, and I'd like to welcome you all to today's presentation. It's entitled OSHA ETS is Stayed. What should employers do now? As I said earlier, my name is Jeff Kopp. I'm a partner at Foley's Detroit office in our labor and employment group. And today I'm joined by two of my esteemed colleagues, Carrie Hoffman and Jacqueline Hayduk. We're going to be talking about the Supreme Court decision and also about the implications of that decision on you as employers, and understanding that there is no now federal mandate that will require employers to force vaccinations or to require weekly testing. So I'm going to jump into the materials. Our plan today is for us to have prepared remarks. Both Carrie and Jacqueline and myself are going to be speaking, hopefully about 10 to 15 minutes each, and then afterwards we'll try to field your questions. Now, given the format of today's presentation on Teams, it would be best if you can email me your questions directly at jkopp@foley.com, that email address that's shown on the screen. And we'll try to address your questions time permitting. If you do have any technical difficulties during the presentation, first, please refresh your browser. And if you continue to have any kind of issues, then please reach out to our email connection at videoconferencing@foley.com. There is not a CLE code or presentation, CLE hours awarded for this presentation, but if that's something of interest to you, I suppose we can look into that further. Let me begin by talking about the Supreme Court decision. As you know, you've probably heard by now about the Supreme Court's decision on January 13th. The matter came before the court as a request for emergency relief after the Sixth Circuit Court of Appeals, which covers the Michigan, Kentucky, and Ohio area, granted an emergency motion by OSHA to dissolve a previously issued stay of the ETS by the Fifth Circuit. So there were a number of cases that were pending in the lower courts, the federal courts around the country, and those cases were consolidated in the Sixth Circuit, and then the Sixth Circuit allowed the OSHA's ETS to proceed, and that's what prompted the review from the to the Supreme Court. Now, the decision came down after oral argument was heard on, I believe, the 17th, the 17th and the 19th. The decision came down, and it was really a split, and the majority opinion decided that OSHA did not have the broad authority that it tried to implement by virtue of the ETS. And specifically, the court looked at the encroachment that the order really would have required that went beyond just the working environment. And so, according to the majority decision, they really believed that Congress had to authorize the OSHA's exercise of those broad powers because of the political significance and the economic significance that the order required. The majority opinion held that really the ETS went beyond OSHA's authority because it involved more than occupational safety and health standards, but it really intruded into such a broad and indiscriminate power such that it went beyond the workplace. And in the court's words, because it couldn't be undone at the end of the day, they believed that the OSHA ETS was just a little too broad. Now, there was a concurring opinion by Judge Gorsuch, and that was joined by Judges Thomas and Alito, and that concurring opinion really focused on a couple legal doctrines about delegating authority to federal agencies. And the takeaway from the concurring opinion really was that Congress and the states had authority to issue this kind of rulemaking, but that a federal agency like OSHA might not have such broad authority with a sweeping regulatory impact that this OSHA ETS would have. And then finally, the dissenting opinion was really the one joined by it was Justices Breyer, Sotomayor, and Kagan, and the dissent really focused on the fact that that really there was nothing in their view that limited OSHA's authority to issue a regulation that would govern the workplace. And so, as you can see, there were some politics involved with this decision because it came down along party lines, so the takeaway really is that this was a technical temporary stay. It's technically really the court's decision affected the temporary stay. Now the litigation is still pending down in the Sixth Circuit and in potentially other courts as litigation continues with respect to the ETS. It's possible that the Supreme Court could ultimately decide the merits of the case, and so the Supreme Court's current ruling that stays the ETS will stay in place until there's further litigation that comes up before the court. Now, practically speaking, it's likely that that this is really the end of the ETS dispute, because OSHA's rulemaking authority on an emergency basis, and that's what an ETS is, it's an emergency standard, and that only lasts for 6 months. And so given the time and the scope, it's not likely that there was going to be a change in the court's position with respect to the ETS until after the OSHA's ETS would have expired in any event. And so what is the impact for you? What we're going to talk about today is really the fact that there may be some questions about whether or not the entire OSHA ETS mandate is affected, whether there are certain implications such as mask wearing or certain provisions of the ETS that might continue to apply. And so there may be some lower court decisions that validate the mask mandate aspect in particular. And the language of the Supreme Court decision does leave some room for that conclusion. But it is likely that OSHA could revert back to its authority under the General Duty Clause. And we're going to see some state law regulations, and Jacqueline's really going to go into that to talk about how that implicates an employer's obligation in the face of the ETS being state. But the takeaway, one key takeaway, is that there may still be potential liability for employers depending on how COVID plays out in the workplace, right? It's possible that with Omicron and maybe some of the lesser symptoms, we might not have, deaths, thankfully. And as a result of that, maybe there are some, it reduces a little bit of the implications of potential liability that we had been talking about previously under COVID with respect to people getting sick and requiring hospitalization and becoming very sick as a result of exposure in the workplace. But we also are going to touch upon, although the ETS itself, or the Supreme Court decision with respect to the ETS itself, does not address two other key mandates that also came down on the federal side, one involving federal contractors, the other involving CMS funding recipients. Now, with respect to federal contractors, there was a separate ETS that came down from the Department of Defense regarding federal contractors requiring their employees to be vaccinated. And it's interesting because with respect to the federal contractor mandate, there was no testing alternative. And so in the face of the court's decision on the OSHA ETS, it's probable that the court may take a similar view with respect to another federal agency trying to implement a broad mandate for vaccines. Now, the interesting thing is, on the same day that the ETS decision came out, the court also issued a decision regarding CMS funding. In that case, Biden versus Missouri, the issue was whether or not the Centers for Medicare and Medicaid Services could, which is division of the Secretary of the Health and Human Services Department, whether they could impose conditions on those entities that receive Medicaid and Medicare funding. And the court actually upheld the decision and said that the Secretary could implement those regulations in the interest of health and safety for people who are furnished services. And so so with respect to certain recipients of CMS funding, the court said, yep, that's okay. You can impose a vaccination requirement. And so I think one of the takeaways here is that the court is looking at specific groups of people who might be working close together or in situations where they're providing health services to the public, and the court is more likely to accept those kinds of regulatory requirements, but is reluctant to just impose a broad, indiscriminate mandatory vaccine requirement across the full spectrum of employees. So, it's an interesting decision. It's not a surprise given the split in the court, but at this point, we're going to move into some of the implications for you, and I'm going to turn it over to Carrie.
So, big picture, what is it we can do now? Obviously, we're not dependent, nor can we blame the OSHA ETS for whatever our policy is going to be. So as HR professionals, we have to decide what it is we're going to do, what's our business going to do to respond to these issues, and how are we going to move forward. I have clients on both sides of that fence, several who were not thrilled with the OSHA ETS, but were happy to blame OSHA for what they had to do, and several who feel like they're free at last. So we have to make decisions. One, what can we do? We can still mandate vaccinations. Nothing in the Supreme Court decision changes as a private employer our decision if we want to move forward and mandate vaccinations. How are we going to do it? You can pretty much use the policy you were developing or had already issued under the OSHA ETS. You may need to tweak it slightly if you decide you're not going to provide testing alternatives and the like, but you can certainly mandate vaccinations. You will have to provide accommodations to individuals based on their religious beliefs, medical excuses, and depending on state law here in the great state of Texas, you have to give exemptions for matters of personal conscience when it comes to the vaccine in the employment context. And so you'll want to double check and see what other state issues may be out there with respect to accommodation obligations if you're going to mandate vaccinations. You can also say we're not going to mandate vaccinations, or we're going to mandate, and if you won't or can't, then you have to mask and test. Same issue. You can, again, you're not obligated to the OSHA rules of testing once a week. You can test once a week. You could test every day, assuming you can find tests available for it. You can do what you want to do with respect to those issues. Big picture is the most complicated part, is likely how to accomplish testing because of the current, at least as I hear it, shortage of testing. One thing to do certainly would be to encourage all your employees to sign up for the 4 free tests that became available if you signed up online at covidtests.gov yesterday. Every household is entitled to 4 free tests. But what are you going to do? Are you going to require them to bring their negative test to work? Are you going to require them to test on site so that you can verify it's them? Or do you just want results uploaded and know you're taking some risk that Carrie Hoffman uploaded someone else's test results because I needed a negative result and I wanted to come to work? Another thing you can consider in developing the policy you want to have is whether you want to demand in-person versus remote work. You're entitled to tell people it's time to come back to work. You're likely going to get some pushback. We all enjoyed working in our fuzzy slippers and pajama pants from home for a period of time. Many employees have pushed pretty hard back on having to come back to work because they don't want to be vaccinated, they don't want to mask, they don't want to test, and it's more convenient for a lot of employees to work from home. But again, you're entitled to tell people it's time to come back to work and what that's going to look like, but you need to consider all of those things in developing that policy, whatever it's going to be. And then big picture, you do need a policy, meaning you're going to have to address these issues. This is a very hotly charged issue on both sides of the mask and test, vaccinate or not aisle, meaning everyone has very strong feelings about it, and you're going to have to address it in some form or fashion, because even though OSHA has not yet formally said how they're going to deal with COVID in the workplace, if nothing else, the general duty clause gives them the ability to determine whether you're providing a safe work environment for your employees. Obviously, we know that OSHA believes that vaccination and or masking and testing is the minimum because that's the policy they wanted to have in place. Obviously, the ETS, as Jeff indicated, isn't in effect, but we should assume from a policy enforcement standpoint, that's part of what OSHA is going to consider, is what have you done to make sure your employees are safe when they come to work. My recommendation is that you continue collecting vaccination cards, including having employees update if they've been boosted. Because if nothing else, the CDC guidance depends on what you need to do to respond to positive COVID, and COVID exposure depends on both whether the employee's been vaccinated and if their vaccination is more than 6 months old for Moderna and Pfizer or more than 2 months old for J&J, whether they've been boosted. And someone who's been exposed and vaccinated in that time frame, less than 6 months for the 2-shot, less than 2 months for the single shot, or has been vaccinated and boosted, doesn't have to do anything. It's if they're not vaccinated or their vaccines are, quote, old and they haven't been boosted, that they've been exposed, that they have to quarantine if they've been exposed to COVID. And then if they obviously have COVID, they have to quarantine. And so that part is important. And even though the paperwork is annoying, et cetera, we need to be cognizant of that issue and make sure that whatever policy we put into effect considers the current CDC guidance. Again, I understand it's been shortened at the height of the pandemic, but that's where we are, and following the minimum requirements of the CDC is the minimum that your policy should consider. And again, remembering that OSHA has always had the power to enforce from a general duty clause, whether you're providing your employees a safe work environment or not. So your policy decision points are we going to mandate vaccination? If we're not mandating vaccination, we still should be collecting vaccine information on all of our workers, unless everyone's 100% remote, because then it does not make any difference. Then we need to decide for employees who are vaccinated, are we requiring masking in the workplace anyway? Because again, we can be stricter than what OSHA and CDC required. If we're not, then what are we requiring for employees who aren't vaccinated or whose vaccines have been too long and need to be boosted? Are we requiring them to mask? And then what are we doing with respect to testing? All of those issues need to be considered in the analysis of what you're going to put out from a policy standpoint, understanding that no matter what you do, you're going to have groups of employees who think you're either doing too much or not enough. And unfortunately, that's part of the game of where we are these days with respect to COVID and the workplace. And with that, I'm going to turn it over to Jacqueline to start talking about state law issues with respect to policies and testing.
Hi, everyone. So as Carrie said, there are a lot of different issues we need to be thinking about if you are going to move forward with implementing either a mandatory vaccine and or testing program. And specifically, one of the big ones is, what do the states that your business operate in say that you can or cannot do? And this issue first really was raised because the OSHA ETS had said, payment for the vaccine is required. It's not necessarily required for COVID testing if that's going to be permitted in lieu of getting the vaccine. But there was mention that, you need to still be looking at state laws in terms of whether or not those laws require payment for the COVID test itself. Now that the ETS as a whole is stayed, we need to be looking at state laws in a broader context regarding a lot of these different issues that are presented by implementing these types of programs. And so what we're seeing right now is that a lot of states, and it's increasing quickly, have laws in place, either general, prior general laws that are being interpreted to apply to these issues, or states are implementing new laws specifically to address these concerns. And those generally fall into three different categories. The first is going to be partial or total prohibitions, meaning the state has some sort of law in place regarding what you can and can't do with a vaccine or testing program. And I'm going to talk about, a high level variations across what states are doing in a moment. And so that's definitely something that you're going to want to be tracking. That will include some states already have in place, actually quite a few have laws that generally say if an employer is going to mandate a medical examination, just in general, that the employer cannot require the employee to pay for them. And so when we can't find a more specific law on topic, you may want to defer to those types of state laws for deciding whether or not you're obligated to pay for testing or vaccination. The second big bucket, is, and that falls into, there's a crossover, wage and hour issues related to who's going to pay for testing and vaccines. And then the third is some states are implementing laws that have to do with what type of entity, whether it's public or private, can request information regarding vaccination status, how the information can be stored, and what requirements there are in regards to record keeping. So we're going to talk about each of those and sort of what we're seeing across a variety of states. Just as a takeaway, sort of the broader landscape is that many states have not issued specific guidance, meaning, like I said, we have to defer to general state laws on those topics. And that's where I mentioned the mandatory medical examination laws, as well as wage and hour guidance on other issues. So many states have laws in place regarding whether or not an employee has to be compensated for time spent either waiting in line, traveling to and from work, donning and doffing. And so in the states where you're not able to find direct guidance on these issues yet, you can look at the wage and hour laws regarding other topics to get a feeling for whether or not the state is likely to ultimately decide that an employer is required to pay for either the COVID test itself, time spent testing, or the vaccination if you're requiring that. Further, while most states have not issued specific laws on these topics yet, we're continuing to see new implementations come up very quickly, or they're revising guidance that they've already issued because of the fact that the OSHA ETS has been stayed, and then the stay was removed and then stayed again. And so it's important to be monitoring these topics frequently. I would suggest on a weekly basis for the time being, especially since we just received the decision from the Supreme Court. So for example, both Minnesota and Illinois have issued guidance in the past week. Minnesota has said that while they previously adopted the OSHA ETS while it was in place, as of January 13th, they are suspending enforcement of the federal standard pending future developments regarding the stay. Similarly, Illinois, which had previously adopted that standard and also put into place sort of their own Illinois OSHA preemptory rules that incorporated that standard and added further requirements, they are similarly staying enforcement pending the stay. And so what we're seeing is states are addressing the fact and trying to give some guidance now that we've seen the stay, but it's very vague. And so what I anticipate is that in the coming weeks, states are either going to, issue additional guidance regarding what they plan to do, or potentially interpreting state laws that are already in place, such as the mandatory medical examination laws that we see many states have, to say whether or not those apply to these types of programs. Hopefully, we're going to continue to see more developments soon. So let's walk through what we're seeing in states in terms of the landscape of who's required to pay for the COVID test if you choose to implement that, who's required to pay for time spent obtaining the test, as well as the vaccine itself. And so I'll start by saying, if a company is going to require testing to be on site, and I believe Carrie started to mention this, is that at that point, the testing is part of the continuous workday for the employee, or at least there's a very strong argument that it's part of the continuous workday under the FLSA. And so at that, if the employer is going to implement a program with on-site testing, then that time spent testing is compensable. If the employer is not going to require testing be on site, but rather the employee gets to go on their off time or sort of has more leeway in terms of where they're going to obtain the test, then at that point we need to start looking more closely at state laws, because there's quite a variety in terms of which states are requiring payment for testing and which aren't. So I'll give a couple examples so you can see the difference. In Arkansas, typically the employer is not required to pay for the COVID test. There is a specific law on this issue, which is SB 739. And what that says is that if an employee prefers testing to a vaccine, the cost of testing will be covered through any state or federal funding made available, specifically the American Rescue Plan. Or and it's only if the employee's health benefits plan then doesn't provide coverage as a secondary means, then employers would be required to pay. So it's only if those two options are not available, meaning state or federal funding or through the employee's insurance, that is when an employer would have to pay for testing. Whereas California, as you can anticipate, they also have a specific law on this issue, but generally under Cal OSHA standards, the employer is required to pay for testing in several circumstances. And I'm not going to go through those specifically, but it's important to note the difference in terms of the approach. The California Department of Industrial Relations has also provided guidance that if an employer expressly requires an employee to obtain a COVID test or vaccination, then the employer must pay for the cost of the test or vaccination, as it's considered reimbursement for necessary business expenses. So further, under California law, payment for the time spent testing is also likely required. Whereas in Arkansas, although there's not a specific law on point right now, based on other wage and hour laws regarding compensable time, the employer would not be required to pay for the time spent testing. Further, one of the variations we're seeing is for states where they don't have specific laws on these topics. So for example, Illinois, and then Wisconsin, there is no law directly addressing these questions, but there was a pre-existing law in both states regarding mandatory medical examinations and whether the employer is required to pay for those. And Wisconsin and Illinois have taken opposite approaches. So Illinois has said that under this mandatory medical examination statute that previously existed, that applies to COVID tests. And the Illinois Department of Public Health has specifically issued guidance that says employers with mandatory COVID testing programs cannot require the employee to pay for testing based on that law. Whereas Wisconsin has said, no, that general law that says typically employers cannot require employees to pay for a medical examination that they are requiring, Wisconsin said, no, that doesn't apply here. This is a different issue, and so the employer is not required to pay for testing. So you can see there's quite a variance in terms of how states are handling this. And it's really important to look closely at whether or not there is specific guidance on the issue from the state, but also whether or not these issues could fall under more general laws. And another area where we're seeing that come up is whether or not these issues are going to be addressed by paid sick leave laws that the state may already have in place that are broader but may apply to these types of situations. And we've seen that in states like Nevada and I believe California as well. There's some requirements regarding providing time off or paid time, not only for obtaining the test itself, but also for the time spent waiting to get the test. And Nevada has a similar law as well. So that gives you sort of a high level overview of the variances. It is going to be complicated if you operate in multiple states to sort of keep track of which requirements you have to meet in each state. But I do anticipate that states are going to be issuing more specific guidance going forward now that the ETS has been stayed and most of these issues are going to fall back on state law. Third, and this is an important area because it covers a lot of different issues, is what state laws are regarding restricting mandatory vax or test programs in a variety of different issues. So what we're seeing is that there's several different types of restrictions or exemptions that states are implementing. Some of them have been in place for several months, even before the OSHA ETS was released, whereas others have been quickly in response to the ETS. And I anticipate, again, we're going to continue to see developments in the next weeks and months. So these buckets are generally that there has to be exemptions for medical and religious beliefs that fall outside of what would typically be protected by the ADA, for example. And so it's a more expansive interpretation of what types of medical issues may need to be accommodated. Same thing with religious beliefs. Further, and Carrie mentioned this, there are a couple states that are saying sincerely held personal beliefs or political beliefs you have to have an accommodation exemption if you're going to have a mandatory vaccine or testing program. So the types of exemptions that are available under state law are broader than what was available under the OSHA ETS. And I'll go through some examples of what states are kind of implementing these types of restrictions. So for medical or religious belief, Texas has said, and there was an order issued on October 11th, banning all entities from requiring vaccination of any individual, including employees who has personal, religious, or medical reasons to object to the vaccination. And the only way that you can have this type of program in place is if you permit for accommodations for these types of exemptions. Another one that we're seeing is prior COVID-19 infection or immunity as an exemption. So both Alabama and Arkansas have laws around this type of exemption. Alabama in November put a law into place that requires employers to provide an exemption for vaccination for medical reasons, which includes prior COVID-19 infection, and Arkansas has a law in place that provides an exemption for immunity from COVID, which can be proven by testing twice a year. We're also seeing some states have a requirement for an appeal process for if an accommodation is denied. Alabama has that, and they require that an employer must continue to pay an employee for 7 days after denying an accommodation request or until an administrative law judge rules on the denial of the request. So that's a very unique one. And then Utah and Texas have exemptions for personal beliefs, as I mentioned. And lastly, one that's also a little bit unique is that Kansas has a law in place that went into effect in November requiring that workers who lose their jobs for refusing to obtain the vaccine to be granted unemployment benefits. So there's sort of a presumption that they're eligible for unemployment. So there are a variety of different types of restrictions that are in effect. Further, we are seeing states that are working on passing new laws that address generally these types of restrictions. There are a few outliers, but you're going to want to be monitoring that. And then one of the other issues is vaccine passports. So a vaccine passport is typically a form of documentation, whether it's a card using an online system or a certification from an employee that confirms the individual has received the vaccination for the virus, and that type of documentation is required to engage in particular activity, whether it's travel throughout the state, attending a public event of a certain size like a concert, or going into work. And so more and more states seem to be implementing vaccine passport bans, meaning they're saying that public entities or state agencies are not permitted to require vaccine passports for use of certain government services. So, for example, both Indiana and North Dakota have implemented bans on state or local units of government from requiring or issuing vaccine passports. North Dakota actually went a little further and said that a state government entity cannot require a private business to obtain vaccine passports. However, a private employer, if they choose to do so on their own, can still do that. And then Tennessee is interesting because SB 14 in Tennessee, which was issued a couple months ago, prohibits employers from requiring proof of vaccination status from any employees or taking adverse action against an employee for refusing to provide proof of vaccination. And so what this means is you can still have a mandatory vaccine program in Tennessee. It just makes it very difficult to enforce because you really can't require the employee to provide any sort of certification or proof of whether or not they've been vaccinated. So it's sort of a backdoor way of limiting those types of programs. And then lastly, what do we expect to see next? So one question that's come up from various clients is whether or not we expect states or cities to implement their own vaccine mandates. And while we've only seen this so far with New York City, it may be something that continues to develop across states now that the federal mandate is stayed. So the New York City vaccine mandate, which only recently has gone into effect on December 27th, requires employers of all sizes. So it's broader than the OSHA ETS with all types of workers, whether they be part-time, full-time, seasonal, to obtain the vaccine in order to be able to continue working in person. There's very few limited exemptions, and something that is interesting about New York City's mandate is that there is no option to test or mask instead of getting the vaccine. It is just a straight mandate that you have to be vaccinated. And so it's quite aggressive. There was a little bit of confusion and concern over whether or not when the new mayor, which took office, Mayor Adams took office in January, whether or not he was going to continue enforcing that. But recently he announced that he is going to move forward with it, especially given the surge in cases in New York City. So for now, we're only seeing that in that locality, but we may see other states or cities implement similar policies going forward, especially depending on what the numbers of COVID cases are in those regions. So that is all we have for today. We'd be happy to take questions for the remaining time. And also, if you prefer to ask your question offline, you can email, send questions to Jeff at jkopp@foley.com, and Jeff will work on, we'll between the three of us, we will get back to you with any of your questions, but please feel free to email them now if you have any. Jeff, do you have any that have come in?
We do, yeah. So let me raise the first question that came in, and thank you, Jacqueline and Carrie, for the excellent presentation. First off, the one question was, can we speak a little bit more about the status of the federal executive order and the anticipated trajectory of that decision, given the CMS decision, whether the executive order that way or the OSHA ETS. And I can tell you that my predictions have not always played out the way that I thought they would have. Early on, I was very confident that OSHA's ETS would really hold up given OSHA's broad authority, and I was wrong, obviously, because of the majority decision of the Supreme Court. But with respect to the federal executive order, and I'll take this, and then maybe Carrie and Jacqueline, if you have other thoughts. But the federal executive order, there was a decision of a district court in Georgia which implemented a nationwide stay of the federal executive order, and that's currently on appeal at the 11th Circuit Court of Appeals. But I think that given the court's interpretation of OSHA's authority across a broad spectrum of employees, not just limited to meat packers or healthcare providers or something like that, then I think it's likely that the administration is going to have a very difficult time trying to enforce a vaccine-only program even without a testing alternative under the federal executive order across federal contractors. So I think that it's likely that the federal contractors, in my view, the federal contractor mandate's probably never going to see the light of day, but I could be wrong. Carrie, I don't know if you have additional thoughts on that.
I agree. I think based on the Supreme Court's ruling, it's going to be very difficult for the administration to say that because of the breadth of what it will impact. I think it will be very difficult for them, but I haven't yet predicted anything correctly in 2022 either. So I hear what you're saying. Okay,
yeah. I guess stay tuned, and we may have a webinar on that one in a few weeks. But let's turn to a different question, and that is, can employers require different requirements for vaccinations and testing for different groups of employees in their workforce?
I mean, again, I think, and Jeff and Jacqueline chime in, but my view would be yes, based on the risks associated. Again, if I'm assuming I'm enforcing these rules under OSHA's general duty clause. I have different rules as they apply to different, my office workers have one set of rules, my production workers have a different set of safety rules. And I think I can justify those types of rules being different under the general duty clause based on my analysis of their work environment. And I think that's where the Supreme Court's decision leaves us ultimately.
And the EOC has also issued guidance on this not that long ago, saying that should absolutely be something that's considered in the analysis of whether or not you're even permitted under the ADA to ask an employee to take a COVID test because it's a medical examination, is looking at what the risk is based on their actual job duties. So, I have had clients that are wanting to mandate vaccination for employees that are working remotely. And I think if you look at testing, for example, someone that's going to come into the office infrequently, maybe just once in a while, because they're a remote worker, there's a question of whether or not it's even necessary or appropriate given what their job duties are and the lack of interaction that they may have with other individuals. So I would agree.
Okay, another question that's come up is for those employees working in states where there's not a restriction concerning asking them about their vaccination status. What do you do if employees refuse to share that information or just outright don't provide it to the employer?
My answer is A, you're the employer, like I'm the parent. What I say goes, either comply with my rules or see later. But the easier option and less severe is to say that I'm going to treat you however I'm treating my unvaccinated workers. If you won't share your vaccination status with me, then I have no choice but to assume you're not vaccinated. And whatever my policies and procedures are for unvaccinated workers will apply to you.
Okay, thanks. I don't see any other questions on coming in through email. So maybe just give it another few seconds. Again, J Kopp, JKOPP @Foley.com if you do have a question. And then we'll just offer a couple of parting comments. And I guess, Carrie, I'll turn it over to you first if you have any other closing thoughts with respect to either the court decision or what employers should be thinking about now.
Yeah, I mean, my big picture is, again, no matter what Supreme Court said and how you feel about it, we have a duty to keep our employees safe when they're at work, and we need to be evaluating our work environment and making decisions, again, in accordance with applicable state laws Jacqueline's provided to us, but making sure we're doing everything we can to provide our employees the safest work environment we can, given the pandemic and where we stand.
Yeah, and I would just add to that, I do think, as you mentioned, policies are very important at this time, especially in the face of the ETS being stayed. So I think it's a good idea for all of our clients and businesses to look at their COVID policy, right? Some of those policies were put in place at different times, and we know how COVID has changed over the course of just the science of the disease. Now with Omicron, it may not be as severe as I mentioned with the Delta variant, and so perhaps it does warrant you as the business looking at your COVID policy and really thinking about the things we've been talking about: mandatory vaccines, testing alternatives, social distancing, working remotely, all of the things that we talked about, and payment for those things, like Jacqueline really focused on, is, and that's a key aspect of all this is, who's going to pay for tests, who's going to pay for time off for employees to get vaccinated, who's going to pay for employees to if they're actually sick from COVID. So those are the key considerations that I think should be in policies, but it really is going to depend on state laws. Okay, Jacqueline, any other parting comments before we close out, or I'll see if there's any more questions via email. I don't see any.
No, I think thank you all for your time. We appreciate you listening, and please don't hesitate to reach out if you have any additional questions, because it is a complicated and fast moving area.
Thank you very much, everyone. We appreciate your time today and look forward to talking to you soon.
Thank you.